Hello and welcome to another Money Monday. My name is Maggie and I'm here with Purse Strings. We're live every Monday, providing some financial tips, tricks, and information to get those wheels turning and to really become financially fearless. So Purse Strings provides all this knowledge, but when we need a professional to go put things in transition or transaction, we have top tier financial professionals who love to work with the female market. And they've all been vetted by Purse Strings, and we call those our Purse Strings approved professionals. And today we have Carissa Look with us, and she is one of our Purse Strings approved professionals. So we're so excited to have you on today.
Wonderful. Thank you. Hi, everybody. Good to have you here.
Would you give the audience a little introduction of who you are before we get started?
Yes, of course. I'm Carissa Look. My firm is Schley, Look, Guthrie, and Locker. I've been certified as an attorney and with the firm for about 9 years now. We have a family practice. I work with my dad's firm. He's been in practice for over 35 years, and so it was really nice to join him on the team. And we actually have my sister working as our office manager. We're with a firm of 3 other partners as well that are about half hour away in the town next to us that practice other areas of law as well.
Awesome. Yeah, we're so excited to have you here. And, we love a family business as well, as Barb and I are mother-daughter. So we always support, those family businesses. But today we're going to talk about 4 big myths of estate planning. And I'm really excited to cover these, but we're just going to start with the basic question of what is meant by estate planning? What does that even mean?
Right. And I want everyone to understand that. Most people think about your assets passing upon your death, and that is one of the main things that it addresses, how your assets will pass and who they will pass to, rather than leaving it to the default provisions in the probate code of who it would pass to. You get to choose, and you get to preserve your wealth in that way for your children or any intended beneficiaries you want to give it to. So that's what's wonderful, that we have options of how you can choose to do that. And not only does it address what happens to your assets upon your death, but we also want to deal with the questions of what would happen if you became incapacitated. We want to provide for that as well. You get to name someone to make financial and medical decisions for you in the event that you were not able to for yourself. And also, if you have minor children, to name guardians for them in the event of your death.
Those are huge, important topics, because those are all very much almost catastrophic moments. So we want to make sure everything is in line and everything's done how we wished it has been done. So we can really take control of that situation, we're taking as much control as we can of that situation, which really helps our family as well with pressure and time and money and all those things. So one of the first myths people go through all the time is that they're too young to have an estate plan. Is this true?
I would answer definitely not. It's true that you possibly, if you are young and don't have a large estate yet, maybe you don't need as complicated of an estate plan. But I believe that everyone should have some form of estate plan. Let's see. So yeah, some of you may have adult children that might be in this position. They think, well, you might be thinking about doing your estate plan, but they don't think that there's any reason they would need to yet. Well, I would say they should look into at least some planning, because every adult can greatly benefit from having one, no matter their age. And unfortunately, we don't know for sure how long we're going to live. So they should have something in place if they have any assets that they want to decide who they would want to inherit their assets. They should at least have a will, even if they are, so they would need a trust. Even if they're young, they could own a home. Even at a young age, they could own a substantial amount of assets. How it works is that anyone who owns real estate should have a trust. If they don't, the real estate would have to be passed through the probate process in order to be distributed to your intended beneficiary. We always want to avoid probate, and I'll explain why later. And if you had, now the number changes with inflation, but right now it's close to $185,000. Anyone who owns over that amount, or an estate that's kind of close to it that they expect might grow to that amount or over, should also have a trust. So even if you were young and owned that amount of assets, you would want a trust. And if you owned under that amount of assets and didn't own any real estate, you still want a will to decide who you want your estate to go to, even with maybe what little you own. At least you can choose the person. And I'd say maybe even more important than that, everyone should have those documents that when I was talking about if you were to become incapacitated. We always like to plan for the just in case. If someone was in an accident and could no longer make their financial decisions or even pay their bills on their own, just physically unable to do so, or had an accident, was in the emergency room, to name that person that they would call to make those decisions for them for the healthcare and financial decisions. So everyone can benefit from having some sort of estate plan, no matter their age.
That's some great advice. And yeah, many young people are still, buying real estate these days to either rehab, to flip, whatever that may be. And like you said, if anyone becomes incapacitated, we are, whenever you're 18, you're now a legal adult. And so your parent can't make those decisions for you. So we do need to stress that, even if you're in college, you need some of this paperwork done. But beyond that, it sounds like most everybody does need this paperwork done, because we need to know who can make decisions when we're not able to make decisions. And that needs to be expressed to everybody else, which this is the best way to do it, the legal way to do it.
Yes, I like how you put that. Yeah.
And so many people, second myth, saying estate plans are only for the wealthy. For those who have the big estate, for the planes, the big, castles that they live in. Is this true?
Yeah, that is a real myth that I would say absolutely not. It's only for the very wealthy. Because like I was explaining, as far as when would your estate have to be probated? Well, if you own real estate or over right now about $185,000 and do not have a trust, then those assets would have to be passed through the probate court. The reason you want to avoid that now, especially if you maybe you're not super wealthy, but you do have some assets you'd like to preserve and some real estate, you really don't want it to go through the probate court, because probate can cost 10 to 20 times more than to go through the probate process. Can cost 10 to 20 times more than to administer the trust that you've set up.
Wow.
And it takes a lot longer as well. It can take a year or more while administering a trust. On average, we would say a couple months to 8 months. And then just dealing with the probate courts, having to, for the trustee or the beneficiaries, your children maybe, to have to make these court dates and get permission from the judge for every step. So that's why it's so much, I really see the benefit that people have, my clients, when they have a trust set up, if they have that amount of assets. So really, these days that wouldn't be considered extremely wealthy, owning one piece of real estate and or over $185,000. But anyone who does would greatly benefit from setting up a trust during their lifetime.
Yeah, it's really important. And I mean, those are 10 times more expensive, and the time it takes, that's just wild to me. And honestly, it might seem like a lot upfront for the first time, but really, if you have, let's say generational wealth that you're trying to pass down, this won't, inhibit it. And your family can really get all that wealth instead of paying legal fees and court dates and all that other stuff later, which if anything happened to somebody, I would not want to make them go through. If anything happened to me, I would not want to make someone go through all of that. rigmarole, as they might say.
Yeah.
And so when we're talking about these estate plans, what are the documents that are actually included in this whole plan?
Yes, and that would depend on the gross value of your estate, what your assets are. So, like I said, anyone that owns real estate or over that amount right now, 185,000 or close to it, they expect their estate to grow to that or beyond that, would have a trust package. If they own a smaller amount, no real estate, then under the 185,000 or far below it, then we would just do a will package and not have to have a trust. A lot of people will need a trust. So the package will include the trust. That's what you set up during your lifetime to hold all of your assets. And that's a way of avoiding probate. It's like the probate court doesn't see your assets when they're in your trust. They're not owned by you in a legal way, of course. And the trust will hold all your assets. It'll have trustees. That's the person who manages or people who manage the assets held in the trust. Initially, it will be yourself or possibly you and your spouse if you're married. And once both trustees have passed away, there's a successor trustee, and that'll be the person who then manages the estate after the death of the settlers, trustees of the estate, and administers the trust to the intended beneficiaries. So the trust in the trust package is really our main document. And then a will, if you were under that $185,000 amount and don't own real estate and just need a will package, then the will would be the instrument that distributes your assets to your intended beneficiaries. It'll serve a similar function as the trust, although it's a little different type of document, but it will distribute your assets. Now, if you have a trust, the will serves an entirely different purpose. We probably usually wouldn't do much with the will, but it's there and it's important. It's there as a safety net because it instructs that any asset, suppose you set up your trust and later you buy a piece of property and you forgot to tell us to title it in the name of the trust. You forgot to tell us about it. The will protect so that property will not have to go through probate, because any property not in a trust normally would have to be distributed through the probate courts. But the will instructs anything that was left out of my trust estate, it should all be poured, the beneficiary of that will is your trust. It should all be poured into the trust. We call it a pour over will is the technical term. And so everything is in effect funneled down through the trust. And those are the documents in the estate plan, the trust and the will, that deal with distributing your assets after your death and managing the assets in the trust during your lifetime. And then we have the documents, of course, that address the question, what if someone became incapacitated during their lifetime and needed someone to make financial and healthcare decisions for them? We have a document for each of those aspects of that. The durable power of attorney, to name a person who can write your pay your bills for you, deal with all of your financial accounts, sign on all of your accounts. They can even sign contracts for you. Wow. So this is someone you want to name who you really trust to make those decisions for you. And then the advanced healthcare directive, which you name a person who can make healthcare decisions for you in the event of an emergency or your incapacity. And another very important part is to fund the trust. So we have documents, account transfer instructions that all of your larger accounts, you'll want to transfer them actually into the name of the trust. So it'll read, you own them as, Tom and Sally as trustees of their trust. So we have the account transfer instructions for you to take to all of your financial institutions and transfer those into the name of the trust. And we walk you through that. And then, of course, if you own real estate, a deed for each of those pieces of real estate to transfer that real property into the name of the trust, into your names as trustees of the trust as well. There's a couple of other ancillary documents that go along with that deed, which I would explain more later to someone who wanted to create an estate plan.
Awesome. So yeah, it's either the trust or the will package, depending if you own real estate or how much money you have. But then there are some other paperwork like the durable power of attorney and the advanced health care directive. And those are two really important ones if you're just over the age of 18. Anybody should really have, just in case you become incapacitated. And, it's not always just, it could be a car accident or, anything can really happen. So we just want to be prepared. But then these other items, the trust and the will kind of catches everything if it's not in the trust. So everything is really packaged together and protected once you have these documents in place. No matter if they're as updated as they should be, everything should be pretty protected. And so another question that I had for you is, let me see what I have here. Let's kind of discuss of what is probate. We keep hearing about this and we know we want to avoid it. But could you explain a bit what probate is?
Yes, probate is the legal process that is done through the probate court, for reviewing the assets of a deceased person, paying off any creditors that they owe to, and then determining who are the inheritors. And the court supervises the entire process. What they'll do first is they need to determine, did the person have a will? And if so, they need to determine the validity of the will. Was the will valid? Did they go through all the steps of signing it correctly? Was that really their last will? So they need to take the time to determine that. Then they'll see who the executor was of the will, and that'll be the person that they're dealing with the entire time, walking through how to distribute these assets. If no executor was named or the person did not have a will, the probate court needs to appoint an executor. And the first thing they need to do is gather the assets, see exactly what the person owned, and then pay any creditors, pay any liabilities they have before the assets are distributed to either their intended beneficiaries that they've specified in their will, or if they do not have a will, it will go in the order of what we call intestate succession, that determines the order of who may inherit, depending on which relatives of the deceased person are alive. So it would go first to their children. If they have no children, it would go to their siblings and extend it out from there all the way to maybe far removed cousins, their heirs.
So it sounds like this not having this will really lets the court decide where everything goes, which is not always what we're looking for. And as we know, that most court processes are expensive and lengthy. So if we really want our assets to go to who we want them to go to, this paperwork is pretty essential.
Mm-hmm.
And then I'm sure you get this question all the time, but can you just go online and make your estate plan? I'm sure, you can Google anything. And many people might think that they don't need an attorney. Is this true?
Well, some people try to do that, and technically you can do that, but more often than not, you're going to end up with your own created estate plan that doesn't really accomplish what you intended it to. And so it would be as if you sometimes hadn't even created one in the first place, and the assets end up being distributed through probate anyway. So I highly advise, again, it's against that, doing your own, leave it to the experts. And I say that not just because I'm an estate planning attorney and I would like the business, but I really, as I've been doing this over the years, I really care about, for people's own good, to have everything set up right. I've really developed a passion for seeing that people handle their estate in the correct way so that their children or whoever they would like to give their estate to can have the assets distributed to them. First of all, preserving a lot of the estate so it doesn't go to probate fees, which, as I said, are quite high compared to an estate planning attorney's fees. And just to make it easier for them, for children, when Of course, when your parents pass away, that's such a heavy, difficult time just to make the process smoother when you're dealing with this aspect of their parents' estate, to avoid the complications, to avoid interacting with the courts, and just to avoid the headache of it, and have an attorney walk them through it who can make it a much more painless and smoother. And so we have had some clients that come to us and say, can you take a look at my estate planning documents I have from 2006 or 2015, and see if they need to be updated. I haven't updated them in a while. And we'll take a look and realize that they had used something like LegalZoom or done it online themselves. And we see that they just really need a new estate plan, because someone could try to research it themselves and spend 6 hours on the internet, but they're still going to miss something more likely than not, because there's a lot involved. They'll probably miss some vital provisions that we'd like to include in all of our trusts, because everything that our trust reads, it's there for a purpose and it accomplishes something important. And not only that, but maybe they'll end up with a trust that is okay. It looks like it could accomplish what they intended to, but they may forget to actually fund the trust. That is one of the most important parts. If you have the trust, but there's nothing in it, it's not going to, if your assets are outside of the trust and you don't have that pour over will set up, like I said, they're going to be distributed through the probate court anyway. So, if you haven't done a deed transferring your home into the trust you've created, then the trust isn't going to accomplish what you think it is. So yeah, go ahead.
It seems like it's really a process where there's not much room for error. You either get it right or you get it wrong, and you don't realize that until it's too late. So instead of trying to reinvent the wheel and learn it yourself, trust someone who went to school to learn how to do it, because that way, all your bases are really covered, and you're not just betting that you did it right, because if you didn't do it right, it really is not much help, to be honest. Yeah. And so you do want to trust a professional, just because you want to make sure all the I's are dotted, the T's are crossed, and all that work actually is worth something, I guess I would say, in the end.
Yes, exactly.
I feel like we've gone through a lot of great information today. Are there any other key points that you want to make sure that we touch on before we finish up?
Let's see. I think I covered most what I would tell someone who is just learning about estate planning. If anyone has any specific questions, I'd be happy to do my best to answer what you would like to know.
Awesome. I'll see if any are coming in this minute. But otherwise, this is something that you have to get done in your legal state, correct?
That's right. Yes. So I'm licensed in California, so I could work with anyone in California to create an estate plan for them. I do a lot of my meetings now over Zoom, as I know many people have been doing. I also meet with clients in person if they prefer that. I enjoy doing that, actually. But yes, I'm able to create estate plans only in the state of California.
Awesome. But I'm sure Carissa could also answer any other questions you have if they come up, or we can help you reach out to a estate planning attorney in your state to get these documents put in order. Again, these are something that you also might want to that you need to update throughout your life, just to make sure that all those people are still there and they're still who you want at your side. And so I appreciate you, Carissa, coming on today and sharing this great education. As you guys can always reach out to Carissa at her emails at the bottom here, clook@slg-law.com. She's also one of our Purse Strings approved professionals, so you can check her out on our site, pursestrings.co. And let's make this an actionable step to get these trusts and wills in place, because they are so very important, and we just don't want to push them off until it is too late. I know it's easy to do, but let's get it done and make an actionable plan. So thank you again, Carissa, and we'll talk to everyone again next Monday.
Okay, thanks, Maggie, and thanks everybody for joining.
All right, bye-bye.
Bye.